just briefly as to the advocates who are there in Supreme Court. So various kinds of advocates. So one is the senior advocate. So most of the top lawyers like Mr. Kapil Sibal, Mr. K.K. Venugopal, all of them are designated senior advocates who are designated by the court as senior advocates. I just briefly tell you what it means. Second category is the advocate on record. I am an advocate on record. Next category can be labeled as advocates who are not a senior, not an advocate on record. They are also practicing in Supreme Court, and the government advocates. So a senior advocate is defined under so-and-so rules and Section 16 of the Advocates Act. And as per Order 4, Rule 2 of the Supreme Court rules, a senior advocate shall not file a wakalat or act in any court or tribunal in India. And he shall not appear without an advocate on record before the Supreme Court or without a junior in any court or tribunal in India. So a person is designated as a senior advocate. It's not something which every lawyer gets. It's not as if every lawyer gets conferred with a designation. So somebody, if the court feels that somebody, because of their contribution, is deserving of being designated, they are designated as senior advocates. And once a lawyer is designated as a senior advocate, it comes with restrictions. And one primary restriction, as I said, is that he cannot appear without an advocate briefing him. They are not supposed to meet the clients directly. So technically, how it happens is, say, for instance, I'm an advocate on record, a client comes to me, I brief their petition, file it, and if you think that a senior is required to argue the matter because of his expertise in the law or of his ability in presenting certain positions, propositions of law, etc., we go brief the senior of what the case is, and then he appears. He cannot directly meet the client. So as per the law, a client cannot directly go to a senior advocate and entrust him with the case. And that is there in the Supreme Court rules as well. And he cannot draw pleadings, meaning he cannot file draft petitions and file it in a court. And he cannot accept direct instructions from the client. In fact, the senior designation system came to be challenged multiple times before the court. And in Indra Jai Singh case, in the 2017 9 SEC, the Supreme Court has held that the designation of certain individuals senior advocate was a reasonable classification. So there is no, it's a reasonable classification is what the court has held. And there is a valid object which is behind that classification. And the said judgment has also laid down what are the criteria. You get points. The court has actually introduced a point system. So if you have publications, you get a particular point. If you have reported judgments, you get a point. Subject to your experience, you get a particular point. So those points are evaluated while considering if a person should be designated. And that's a 2017 judgment, which came to be revisited by the Supreme Court in 2023. And an order dated 12/5/2023 was passed by making some modifications on the criteria, based on which a senior designation is being done. Similarly, the High Court, there was also designation done for lawyers who are primarily practicing in the High Court. Then you have this advocate on records. So as I told you, I am an advocate on record. It is only an advocate on record who can file petitions in Supreme Court, who can file a wakalat in Supreme Court. Under the Advocates Act, otherwise there is no bar. Any lawyer can practice anywhere. So technically, say for instance, I don't think any High Court has this advocate on record system. So any lawyer can file a petition, file a wakalat on behalf of a client and appear in those matters. But in Supreme Court, it is only an advocate on record who can file a case on behalf of a client before the Supreme Court. So for instance, I became an advocate on record only in 2017. So prior to 2017, if in case somebody had approached me saying, I have a case in Supreme Court, I could not have filed it. So I would have had to take it. Probably I as a lawyer would have drafted the petition, but I would have had to take it to an advocate on record and request him to file the case on my behalf. It is filed in his name. And then I may ultimately appear because an advocate is entitled to appear in a matter. But the filing of the case in the court can only in Supreme Court can only be done by an advocate on record. So that's a restriction which is imposed, probably to streamline the process because the apex court, the topmost court. So they wanted to streamline as to who file cases, put lawyers being responsible for it, etc. Because there are also conditions that he should have his office within 16 kilometers of the premises. a clerk is required to be registered, so that the cases are being conducted diligently in the court. Probably they would have envisaged that a lawyer practicing in some other place may not come file and later not be responsible for the case. Probably that's why an advocate on record kind of a system came to be introduced. Now it needs to be seen in the present circumstance where it's e-filing, you have VC hearings, you can appear from anywhere, you can file from anywhere. Whether such a system is required is something which we will have to wait and see what happens. So I've just generally told you which order rule deals with advocate on record, and a non-senior senior advocate can register as an AOR. And the general criteria is that an advocate should have been enrolled in the State Bar Council for at least 4 years. He should take a training under an advocate on record who has 10 years of experience, and that training should be for a period of 1 year. So 4 years of practice anywhere, being in the roles of the State Bar Council. Thereafter, for 1 year, he should have undertaken a training under an advocate on record who has 10 years of experience. And thereafter, you give an examination. And that exam, there are 4 papers. There is practice and procedure, Supreme Court practice and procedure, leading cases, you have professional ethics, and drafting. These are the 4 papers. You pass this examination, then you will be an advocate on record. And as I told you, the restriction is that you should have an office within 16 kilometers of the court. And within 1 month of the registration, you should have a clerk. Now, I've told you senior advocate, I've told you advocate on record. Next is the category, the other lawyers who are enrolled with the Bar Council anywhere, but who is neither a senior counsel nor an advocate on record, but they are also entitled to practice in Supreme Court. Like the example which I told you prior to 2007, when I became an advocate on record, I was just an advocate. So I was entitled to practice in Supreme Court. I was entitled to appear in cases as well. Just that I could not file cases. So if I had filed it through somebody, I could have appeared in those cases. So they are those advocates. You have these government lawyers in Supreme Court. One is the Attorney General, who is the highest law officer, who represents union government. Though Attorney General is a constitutional post, technically it's not a government post as such. Solicitor General is the second highest law officer of the country. Then you have these additional Solicitor Generals and panel lawyers, etc., who represent the union government before the Supreme Court. Similarly, every state government usually appoints standing counsel, and you may have panel lawyers and AORs as standing counsel who represent the state government for litigation before the Supreme Court.